Module 3 Defences. If you write or say something that causes serious harm to someone's reputation, this doesn't necessarily mean that you will be liable and required to pay damages. There are a range of defences available to people who are sued for defamation, which, if deployed successfully, would prevent a claimant from being able to get damages from your organisation. These defences exist to provide a balance between, on the one hand, the rights of individuals and organisations not to have their reputations unjustifiably harmed, and, on the other, the right to freedom of expression and the right of the public to receive information. An understanding of defences is important because it enables publishers to make informed decisions about whether there is likely to be any legal risk in saying or writing something that is harmful to someone's reputation. When planning and conducting a research or investigative project that is likely to criticise people and organisations, it is advisable to have regard to the defences that may have to be relied on. The public interest defence is relied on every day by journalists working for serious newspapers and broadcasters, and it is also highly relevant to the work of campaigning organisations. A good way to protect yourself from being sued for libel is to ensure that you could defend your publication on the basis of the public interest defence by acting responsibly when making serious allegations. Unlike the truth defence, which is discussed next, a publisher does not need to show that the allegation is true, just that the requirements of the public interest defence are met. This defence has two main elements. First, a publisher has to show that the statement was on a matter of public interest. This is relatively easy, as most publications concerning serious political, economic or social issues or topics of public concern will be on a matter of public interest. NGOs which campaign about corruption or human rights or poverty or environmental harm will be publishing information on matters of public interest. Secondly, the publisher must show that it reasonably believed that publication of the statement was in the public interest. This is considered in the next slide. To rely on the public interest defence, a publisher needs to show that they reasonably believed that publishing the statement was in the public interest. This means that the publisher must not only show that he believed that publication was in the public interest, but also that his belief was objectively reasonable in the circumstances. When a court looks at whether a publisher reasonably believed publication was in the public interest, the focus will be on whether the publisher acted responsibly and fairly when making the allegation. The court will look at all the circumstances of publication, and the kinds of issues that the court would address would be: did the defendant use reliable sources, or at least sources he had good reason to believe were reliable? Did the publisher believe the information to be true? Had the publisher taken reasonable steps to check the accuracy of the allegation? The tone of the article or report, was it responsible or was it sensationalist? And was the allegation put to the claimant prior to publication? It is clear from these factors that even though a defendant doesn't have to establish the truth of an allegation for this defence, they do have to show that they used reliable information, took proper steps to investigate the allegations, and acted fairly by putting the allegation to the person concerned before publication. So what happens before publication is very important when seeking to rely on this defence. No one factor is determinative. For example, it is not always possible to get comment prior to publication of an allegation, but a court will look at all the circumstances. As the guidance in Module 4 shows, you can protect your organisation by making sure your publications meet the standard of the public interest defence before publishing a serious defamatory allegation. A person publishing a defamatory statement will not be liable if she can show that the statement was substantially true. If a defamation claim were to go to court, the court would decide on meaning, and it would adopt a single meaning that the publisher would have to defend, as explained previously. But at the decision-making stage, a publisher has to take its own view as to what meaning a publication will bear, and whether, if it was required to, it could defend that meaning as being true. The facts that are necessary to establish that a statement is true will depend on the specific allegation, but these are two common examples based on the categories of allegation we explained in Module 2. If a statement alleges that a person is guilty of having done something, a defendant could only succeed with a truth defence if she can prove that he is in fact guilty. This is why it is high risk to make or repeat an allegation that someone has committed a particular act unless there is clear evidence to support the allegation. So if you allege Mr. Jones is corrupt, you have to prove Mr. Jones has in fact acted corruptly. If the allegation is that there are reasonable grounds to suspect a person of having done something, a defendant arguing that the allegation is true would need to show that there are facts which give rise to grounds for suspicion. This is much easier than proving guilt. So if you say there are reasonable grounds for believing Mr. Jones is corrupt, you have to prove the facts that support this, for example, the evidence of suspicious dealings. For a statement to be substantially true, it is not necessary to prove that every detail is true. A person defending a statement as true need only show that the overall allegation, which is sometimes called the sting of the libel, is true. So if, for example, it was alleged that during a criminal investigation a police officer beat every detainee, but at trial it became clear that the police officer had beaten the majority of detainees, but not all of them, the publisher would succeed with the truth defence because the substance of the allegation, that the police officer beat detainees, had been established. Equally, if in a single publication there are separate allegations with different degrees of seriousness, it is usually sufficient for the publisher to prove only the most serious allegation. For example, if it was alleged that a police officer beat and swore at a detainee, the publisher would win if he established the assault allegation, even if the swearing allegation was not proven.